Is that coming on? Okay, good, good. All right. So just obviously raise your hands if at any point you're having difficulty hearing or if the audio cuts out. Overall, these Zoom meetings are working pretty well, but from time to time, this issue happens. So what I'd like to do today is talk a little bit about what's happened in the last few days, and then give you an update on the voting, and then just open it up and answer questions. The goal, and I see there's at least one person having an issue with hearing. Are people able to hear? Hear? Yeah. Okay, good. All right. Mr. It looks like Earl, an issue with hearing. Okay. I think it has to be on your end because everyone else is signaling that they can hear. Yeah. Okay. So here's what's happened over the last week or so since we last had one of these meetings. On Tuesday, we had an overall panel that was not just people that were in favor of the deal, but we also had a couple of the attorneys who are opposed to it. And I thought overall that went pretty well. I don't know if any of you had the opportunity to listen in. It was put together last minute, so although we put the notice in the letter that went on Tuesday, it may well be that you didn't get a chance to listen to it. If anybody's interested at all in hearing different sides, what different people have to say, I really encourage you to go onto our website. Once we obtain that link, we are going to post it. It is proprietary. The host that put it on owns it, but we're hoping to get that and we can put it on, and that way you can hear different sides. So there are a couple of questions that we have right now, and let me answer those, talk about voting, but before we do that, I did want to let you know that there was a very brief hearing today. Nothing really of significance happened. All that happened was the judge set a date for hearing the estimation motion, and the estimation motion is simply in the event that the fire victims vote to approve the plan, in the event that 2/3 of those who vote in favor of it, then the restructuring support agreement, the RSA that we signed with PG&E, requires us to go before an Article 3 judge, which is different than a bankruptcy judge. This would be a full federal judge, and obtain approval. So that is set for the 21st of May. We had a status conference on that. It was very brief, took less than a half an hour, nothing much happened. The one thing that I also wanted to say before we get into some of these questions that we got online is this has to do with the bankruptcy hearing that we had on Tuesday and what the outcome of that was. There were a couple of reports in the paper that talked about PG&E having the ability to pay fines out of the trust. And it didn't receive a lot of coverage. There was nothing in depth, but from a couple of the articles I saw, I don't think it was accurately reported. So I want to lay out exactly what happened to make sure that everyone understands it. As all of you know, PG&E pled guilty to 84 counts of involuntary manslaughter and 1 count of starting a fire in connection with the campfire. They agreed to pay $3.5 million to the county of Butte as both fines and penalties. And so it got a little bit confusing in terms of where the money was coming from, because technically it couldn't be paid by PG&E, the reconstituted company. So what happened was the insurance companies are the ones that put the money up. So they were the ones that paid it. It did not come from the individual fire victims. And again, I know it was a little bit confusing in terms of how it was reported, but this came 100% from the subrogating insurers. These are the various insurance companies, not from the individuals. If anyone would like to see the order, we are going to post it online, and I'm happy to send it to you. But again, I know there was confusion, and it's completely understandable. Obviously, it would have been outrageous for the individuals to have to pay that. That didn't happen. So I just want to make sure that that is crystal clear. And I think some of the confusion came from the next part of the hearing, because there were two motions on calendar. The first was for the approval that the judge approved that this payment could be made by the subrogating insurers. And then the second one had to do with the request that all of the individual plaintiffs made. And this was not just my group or our group. This was not just some of the other attorneys who are supporting the plan. It was the TCC. It was all of the individual attorneys. And the request that we made was that the court allow PG&E to advance a certain amount of funds so that the claims administrator, the trustee, and all of the people who are working on this could get started. The reason we felt that was critical is that we want to make sure that as soon as the trust is funded, which is currently set to happen on August 29th or before, but as soon as it's funded, then the trustee and the claims administrator can start passing out the money. Again, one of the conditions that we had for hiring them was that they gave us their word there would be no artificial delays, and as soon as the money came in and they were ready to disperse it, they would do so. The problem was that in order to process 77,000 claims and to create this whole system, they had to hire roughly 250 people. And so that was going to take a lot of money, and this needed to be advanced. So we went back and forth and we worked something out where PG&E is paying $2.5 million out of their pocket to fund it, and they're advancing another 19 million. Now that is an advance. It will reduce the overall amount, but it's not something where that money is going to PG&E. The money is going directly to Brown Greer, which is the service that was hired, Justice Trotter, Kathy Yanni, and those people, in order to make sure that the system is up and running. It's going to take quite a bit more than that. The administrative costs in this case will be somewhere between $50 to $100 million, according to current estimates. Obviously, could be a little more, could be a little less. Those are our best estimates. We understand that's a ton of money. The problem is there really is no way other than hiring these people to get these 77,000 claims administered. So that's what the money is for. And again, it's not something where PG&E is allowed to siphon money off. What's happening is PG&E is advancing that money, and then it will be deducted from the amount that would go into the trust. So those were the two main things that happened at the hearing. The other issue that is coming up a lot right now is voting by phone. A lot of people like to use their smartphones. I mean, we all have them. We all use them all the time. And a lot of people wanted to use that to vote for reasons that are completely beyond me. And I frankly, this was very upsetting. I don't understand how Prime Clerk allowed this to happen, but Prime Clerk, which is the vendor that was hired by the bankruptcy court, not hired by any of us, hired by the bankruptcy court to monitor the vote, for whatever reason, their system does not accept votes by smartphone. And so particularly now in social distancing, where people can't go into the office, they can't go to a library, they can't go to a friend's house, if you happen to not have a computer at your house, that creates a significant problem. So we've been in touch with Prime Clerk, and we've worked out a system so that we should be able to get your votes done if you don't have access to a computer right now. So I'm going to read out what we've worked out so that it's exact, and we'll also put this in the next update letter, and you'll be receiving texts and notices both by email and by text so that you can follow this. So here's what's going to happen. Again, all of the previous instructions are still correct, and you can still vote online if you have access to a computer. If not, what we're going to do is we're going to send you a text, and that text is going to have some instructions that are going to say, if you want to vote by text, essentially, in other words, if you want to tell us how you want us to vote for you and fill this out and send it to us, then we can do it. You go through, you follow those, and that will, it's very self-explanatory, but it will allow you to do that. And the way that we ensure that everybody's vote is accurate is we keep a copy of that text that you sent us. So it would be a text, it would say, if you want to vote yes, do this. If you want to vote no, do this. Put in the name and the last 4 digits of the social security number for each person who want to vote. You do that, you send it to us, we put it in your file, and then we vote accordingly. And Prime Clerk has told us that we can do this. So that's how that works. The other thing that I want to kind of walk you through, just in case anybody is having issues, is how you fill out an e-ballot. Remember, you have to get your e-ballot number, which is the long number. Then you go to Restructuring, Prime Clerk, PG&E, e-ballot home to cast your vote. You enter your name, email address, and e-ballot number. The website will then take you to an online document that is the ballot. On page 7, you either hit accept or reject. On page 8, it asks you for your personal information. Again, it's completely up to you. You can put in your social if you want, but we strongly recommend that you only put in your last 4 digits. Once you do that, you hit submit, and Prime Clerk will send you a confirming email with an attachment showing a copy of how you voted. The other thing I really want to stress is that everyone in the household has the right to vote. So if it's yourself, your partner, and you have 3 children, then you would have 5 votes. For minors, the way that it works is you would put in their name and their social, but you would be the one who cast the votes for them. Again, if you have any issues at all, please let us know. So let's go through the questions that were asked from clients prior to this, and then we'll open it up and take everyone's questions. The first question is, if the settlement plan is rejected, what happens? The answer to that is that while we cannot know with any certainty, what is most likely to happen is that the court will institute the contingency plan that it approved 2 weeks ago. The contingency plan calls for a transition officer to be appointed, and then that officer will sell off PG&E's assets as quickly as he or she can. Ideally, what would happen is there would be a buyer for the entire utility, and they would be able to sell it off. That is not going to happen based on the fact that they've been trying to sell the utility for quite some time. Governor Newsom reached out to a number of individuals, very famous ones like Warren Buffett, and then lesser known people that operate utilities. No one was willing to buy it. So because of that, what will happen in all likelihood is it will be broken up and sold off piece by piece. This will likely take 2 to 3 years. At the end of that period of time, there will be an amount of money that will have been obtained from selling off all the assets. Because bankruptcy sales are typically much less than what you would get on the open market, we're estimating that you're probably looking at 60 to 70%. So if PG&E has $66 billion in assets, it's probably going to get somewhere between 45, maybe 50 billion. The current amount of claims in bankruptcy is 59 billion. So that means that everyone will take a discount. How much, we don't know, but I personally believe, and pretty much all of the analysts agree with this, if the company is sold off, everyone will get significantly less than they would get if this plan goes through. Now, again, that does not have to happen. That's the contingency plan that the court approved. However, the court could always do what is called a cram down. And a cram down is just like it sounds. It's a very inelegant way of saying that the judge can take a plan, and it could either be this plan or he could modify it if there were someone who was willing to put up the money, and then essentially cram that plan down everyone's throats. That would be the plan, and that would be that. So again, he has the right to do that. He's indicated that he would not, but that technically is another possibility. So that's what happens if the settlement plan is rejected. Next question is, when will attorney fees be deducted? Attorney fees are deducted after you are paid. So let's say that you go through and you get an award of $500,000 from the claims administrator. The trustee would then issue a payment of, again, it probably won't be 100%. It'll probably be somewhere around 80%. Could be a little more, could be a little less. Let's just use 80 because it's a round number. That would mean that the trustee would issue you a check for $400,000. From that $400,000, we would be paid back for any costs that have been advanced, and we would receive our fees, but that only happens when you are paid. And again, we would only be paid on that 400, not on the full 500. We're only paid based upon what you receive. Next question is, has the percentage of PG&E stock fire victims own been calculated? I hear so many conflicting answers. For instance, will we own 20.9%, 21%, 22%? And then the next question is, if so, today's market capitalization for PG&E stock is $6 billion, and 20.9% of that is $1.2 billion, not the $6.5 billion promised. So those are very good questions. And let me answer that one at a time. The first question is the percentage. And what the RSA says, and the RSA is the Restructuring Support Agreement, that's the deal that we signed with PG&E, is this. The absolute minimum that fire victims can receive is 20.9%. However, there are anti-dilution provisions that have been put in to make sure that the amount is $6.75 billion. Now, again, when I say make sure, there are no guarantees, but when Governor Newsom insisted that PG&E pay more for system hardening, which was an excellent thing, I'm certainly glad he did that, but when he did that, PG&E then had to raise several billion more in capital. So to do that, they issued more stock. And so to prevent our share from being diluted, the amount that the individuals are going to receive was increased. And the exact amount is going to be determined based upon a number of factors that we won't know the answer to until the underwriting is complete. But the minimum amount is going to be 22.4%. The maximum amount could be 23.5%. We will know the number as we get closer and closer to the, it's called the effective date, and that's the date the stock funds and is calculated, which again, currently is scheduled to be August 29th. So that's the first question. The second question is, okay, how is it that our 20.9% or 22.4% is going to be 6.75 billion if PG&E only has a market cap of 6 billion? And that's an excellent question. And to answer that, it's important to remember that when we talk about what your share, what the trust is going to receive, that 22.4%, we're not talking about PG&E today. When PG&E goes through the restructuring process, that is when the plan is approved and when the court issues the final order, PG&E as it exists now is converted into an entirely new holding company, and the stock is completely reissued. And that stock is going to be very different. It's going to be related to the current number in the sense that if you were someone who owned stock or owns stock now, then where you bought that stock at, the number that you purchased it at, is going to relate to how many new shares you get. So if, for example, you purchased it at $3 a share, you're going to get less, or you're going to get more than if you purchased it at $16 a share. But again, that is going to only relate to how many shares you receive. The value of the company is going to be much, much higher. Again, it's going to be 14.9 times the earnings. The earnings are, and we did a very brief explanation of this and put it in the last letter. So if anybody's curious, I would encourage you to look at the end of the last letter where we lay it out. But what we do, and what they do when they're doing this, is they take the anticipated estimated earnings from the next fiscal year, they multiply that by 14.9, and then that's the total market cap of the company. It's currently estimated to be somewhere in the low 30 billions. It should be somewhere between 31 and 35, depending upon a number of different factors. From there, you calculate 22.4%, and that's where our stock is going to be. That's the minimum. Again, it could be more, it could be as high as 23.5, but that's going to be the minimum. And when you do those calculations based upon the current estimate, the most recent estimate of the anticipated earnings, it comes out to 6.75 billion. Again, I want to stress there are no guarantees. The stock could be worth less than 6.75, but we certainly believe it's going to be worth that or more. Okay, that answers the next question. This one is related, and it has to do with the stock price. And again, the most important part of this question is, when is the price going to be established? That will be on the effective date. And the effective date is the date when PG&E issues the shares and has to fund the trust. Under the RSA, that date has to be on or before August 29th. So that is what everybody is going off of. We certainly hope it'll be in July, but it could be August 29th. Now, technically, it could go past that. If it does, we, the fire victims, have the unilateral right to walk away from the deal. We don't need anybody's permission. We can just say the deal's off, that's it. And depending upon what the circumstances were, we might end up doing that. Everybody believes it's very unlikely that will happen. PG&E faces severe penalties from the CPUC if they do not fund by that date, but it certainly is a possibility. You know, the deal obviously is not final until the check clears. So that's what we're waiting on. We think it'll be August 29th, but we don't know. The next question has to do with what happens if someone dumps a vast amount of shares. In other words, let's say someone owned 5% of the company and just sold it all at once. If that happens, then obviously the stock is going to go down. It's very unlikely that would happen, though, for a number of reasons. The first is that as part of this reservation of rights agreement, or restriction of rights, that we're working on with PG&E, this is going to apply to all major shareholders. So it's not just the trust, which will be the single largest shareholder, but it's all of the hedge funds that own, 3, 4, 5, up to 10, 15% of this company. They are restricted as well. Nobody can just walk in and dump a massive amount of shares. How much you can sell is limited, and the same restrictions that apply to us will apply to all of the other major owners as well. Okay, the last question is, are the insurance companies also getting 80% of their money now and the rest later? The answer to that question is no. They are receiving the full amount of their funding on the effective date of their RSA. And the reason for that is they had 19.5 billion in losses. They accepted 11 billion in settlement, which is a reduction of over 40%. It's around 58%, 58 cents on the dollar. And in exchange, they received that amount up front. Obviously, we were not willing to do that. We insisted on what we believe was full value, the 13.5. Hopefully it will be. If it is a little bit less, again, I don't think it will be, but if it is a little bit less, then that will be done on a pro rata basis. But either way, we're going to get 90, 95, hopefully 100 cents on the dollar. Because of that, we did have to take some in stock. And then in addition, because the trustee owes a fiduciary duty to everyone, not just the first people paid, he's going to withhold a certain amount until he's sure there's enough to pay everyone. So those are the issues that I wanted to raise. What I'd like to do now is just open it up and answer any questions that people have.
And for everybody watching us, there is a raise hand option. Should be at the bottom of your screen. If you have a question, please use that function, and I will make sure to go through as many questions as possible.
Go ahead. Oh, actually, real quick, while we're waiting for Chewy, there were two other announcements I wanted to make. One is that on Saturday, we're going to be doing a town hall with a number of other attorneys. All of us who represent a large number of people, I think collectively the attorneys on this represent over 30,000 people with all the 5 firms together. We're going to get together and do a town hall where we answer questions from all our clients. The goal being we want to make sure that everyone receives the same information, and that if there are questions that some people have, everyone has the opportunity to hear it. You're going to get a call tomorrow and another call right before the town hall. If you'd like to listen in, just stay on the line. It's a robocall, or if you want to stream it, you can go to the website, firesettlementfacts.com, and that will be on the call as well. The other thing that I wanted to let you know is that we are going to be sending out texts in order to let you know what your options are to vote. And if you haven't voted, to remind you to vote. This is a very important decision. We want to make sure everybody participates. We don't want it to be a situation where one of those things where people meant to vote but didn't get to. Whether you vote yes or no, we do want to make sure everyone has the opportunity to do that. Okay, Chewy, are you ready?
All right. Yes, Mr. Cantu, go ahead.
Could you revisit how you came up with the figure of 13.5 billion? I know you've done it in the past, but could you please just revisit that? That's my first question. And the second question is, we have not received a mail-in ballot. We have not received any mail from Prime. We tried voting online and we kept getting kicked out, timed out. You can't do this.
Yeah, let me address the second one first. And again, this has been a very frustrating experience. You know, I don't want to be overly critical because you know, I'm not a tech person, but in my observation, I don't believe Prime Clerk has done a great job, and I'm really sorry that it's been difficult for you. So what we're doing to work around that is to set up a system where we'll text you. You can text us back what you want us to vote, then we can log on. And if you like, we can just, you know, print out something and send it to you so you have a confirmation. But we want to make sure everyone can vote. And unfortunately, Prime Clerk, there have been a lot of problems. So I do want to apologize for that. In terms of the first question, the 13.5, that was arrived at in a couple of different ways. Essentially, we had two goals. We wanted to get the most we could from PG&E, and then we wanted to make sure that what we received was enough. And the estimates varied widely in terms of what it would take to make everyone completely whole. The reason for that is that while we may know what our 7,000 clients are claiming, there are a number of people who are unrepresented. There's about 12,000 people that are unrepresented. So as you can imagine, it's very difficult to get information from those folks about what the nature of their losses are. And then there are other attorneys who have not yet done the workup for their clients. And so it really is estimating. And particularly when you're looking at 77,000 claims, you have a wide variance, because we figured that there were about 2/3 that we had almost no information for. So if it turns out that those 2/3 are not serious cases, if they end up being majority smoke and ash, things like that, then the overall amount of the claims is going to be significantly lower than 13.5. It should be around 11 billion or so. On the other hand, if every single one of those is a serious home loss, then it's going to be above 13.5. It'll be, you know, somewhere in the mid 14s, maybe as high as 15. based upon the best estimates we had at the time and to date, we think 13.5 is going to be enough. And that's based upon all of us giving information regarding our claims to Brown Greer, which is a company that basically runs models and determines what they think it's going to take to pay all these out. In addition, the TCC and some other individuals had financial experts that looked at it and projected. So that was one calculation. The other was how much could PG&E pay? Initially, PG&E, well, initially they were offering about $5 billion, but they kind of stalled out at about $8.4 billion. And that was the most they were willing to pay. According to them, their experts said that was going to fully compensate everyone. We obviously didn't think so, so we went back and forth. And what we basically did was to pit the bondholders and the equity holders against one another. And we would go back and forth and get them up until we finally got the bondholders to 13.5. And then we had PG&E, the equity, which is the current deal, match that. For a variety of reasons, we thought the equity deal was better. So that was the one that we ended up signing. But both of them were exactly the same in terms of the basic terms. It was $6.75 billion in cash, and then approximately $6.75 billion in stock based upon the formula that was worked out, which is the 14.9 times the earnings. So those are the two ways that we got to the 13.5.
Okay. I have a question from Mr. Kevin Skinner.
Sure.
Two questions. At what point and who are we going to meet with to tell our story to determine how much we're going to sue for? And the second question is, you gave the example of being awarded $500,000, you would get 80%, and then our fees would be deducted out of that. But is that, how does your 33%, my understanding was, is you're going to, if we sue, let's bring it down to 100,000, then you were going to sue for 133,000 to
Right.
get your fees out of that. Is that still correct? Okay.
Absolutely. So let me answer those questions in reverse order. Answering the first question, which is, are we going to ask for fees and costs? You also get your costs on top of the economic losses. The answer to that is yes. Now, individuals who don't have an attorney, and there are, again, somewhere between 10 and 12,000, they will not be awarded fees because they don't have an attorney. But anyone who has an attorney will be awarded fees based upon what their contract says. So that one is yes. In terms of who you're going to talk with, prior to COVID-19, most of these would have been done in person. Now with social distancing, it's either going to be Zoom or over the phone. But we have been reaching out to all of our clients. If you haven't been contacted yet, you will be soon. And what we do is we put together a packet that has all of the information. So if you lost your home, for example, you would need a contractor. In all likelihood, you would need an arborist to talk about any trees or vegetation. You would also need many times an erosion expert, and you might need some other expert. We get all those reports, we get the personal property list, and then we get the narrative. We put all that together, we calculate it up, we put attorney fees on and costs on top of that, and then we submit it. So that's how it works.
I have, there's a question submitted via the chat. It's, what is the lowest settlement amount we can receive? And the second question from the same client is, why aren't we being encouraged to wait until the deadline to vote?
Okay, two questions that are very common, so I'm glad they were asked. In terms of the second question, and let me answer that one first. Or actually, let me take the first one first. So what is the minimum amount you can receive? It depends on what your damages are. We have seen cases in the past where people sued solely based upon evacuation. That was the only thing they did, and they didn't have a troubling evacuation, but they were out of their home for a week or so, and then they came back. Somebody like that, I don't think there are going to be many of those, but you're probably looking at a few $1,000s. That's not somebody that we would accept. We generally tend to take people that have at minimum some damage to their home, whether it's smoke and soot or something else. But again, if the only damage you had was that you evacuated, but you didn't, encounter any flames and you weren't in danger for your life, you spent a week at a hotel, you had to eat out, you're going to get compensated for that. And again, something fairly minor for having gone through it, but that's going to be the minimum. In general, most people are going to receive whatever their economic damages are. On top of that, they're going to receive the attorney fees and costs, and then they're going to receive something for having gone through it. So I think that's going to be a significant amount. I guess if you only had smoke and soot damage and most of it was compensated by insurance, you could be looking at, and you didn't have a troubling evacuation, you could be looking at, 15, 20, 25,000. But again, I don't think that's going to be the majority. I think the majority of people are going to have some gap between what their insurance paid and what they suffered, and then have some type of non-economic damage as well. The next question is, why aren't we encouraging people to wait? And that's an excellent question. And the answer is this. The deal is the deal. It is not going to be renegotiated. One thing that I'm sure of, and I'm not sure the sun is going to come up tomorrow, but I'm very sure that PG&E is not going to renegotiate this deal. It was negotiated before. All of us who negotiated felt it was a good deal. And frankly, the voting that has come in, those people that have voted, it's been overwhelming. Just from us, it's been over 98%. Every attorney I've talked to has similar stories. I mean, I think the lowest one is about 95%. The problem here is there just really are only two options. One is we approve this deal, or two is we don't, in which case there is a prolonged bankruptcy. It's going to take years, and then there's going to be significantly less. So that's why the vote has been so overwhelming. If there was a situation where there was something to be gained by voting, then I would absolutely be in favor of it, but that's simply not the case. So my view is, if you don't know how you're going to vote, then by all means, take all the time you need, get as much information, call me. You all have my cell phone number, but if you don't, it's 619-405-3056. Call me, ask me your questions. I will answer them. If I don't know the answer, I'll find out and I'll get back to you. You deserve all the information. Once you've made your decision, though, whether it's yes or no, I would really encourage you to vote. I just don't think there is anything to be gained by waiting. That's why I personally am not encouraging anyone to wait. To the contrary, I think once you make your mind up, it's a good idea to vote, and that way you can be sure your votes count.
I have a question that was submitted via the chat. It says, Chris Trostel.
Kurt
Trostel.
Yeah.
My apologies. Who resigned from the TCC, posted on Facebook some concerns and noted potential issues that are likely significant costs that would be deducted from the fire victims' trust amount. Can you comment?
Certainly. Mr. Trostel was on the TCC and resigned about 3 weeks ago. I certainly respect the right of everyone to voice their opinion, and obviously he is not in favor of the deal. He has every right to say that. I have been concerned from time to time about some of the information that comes out. For example, I noticed he had a post, I believe it was yesterday or the day before, where he said, and I think he used the word siphon, that the judge approved 19 million be siphoned from the victims by PG&E. And again, this certainly may not be his fault. It may just be the way it was reported. But what actually happened there was that PG&E advanced the money. They agreed to pay $19 million to the trustee for the claims administration. Now, again, that's a ton of money, and the claims administration process is going to cost a very large amount of money. There's just no way of getting around that. To put it in context, it is important to remember that we're also going to be earning interest on any of the money that is not paid out. and certainly it's going to take quite some time to pay all this money out. So if you just take the $5.4 billion that is going to be deposited immediately on August 19th, that amount at a very low interest rate, say 1%, comes out to around $54 million per year. So when you look at just the interest on that, that's going to be substantial. There's also the stock appreciation, and there are the third-party claims. The goal is that the trust administration and all of the other settlements, the state of California, the federal government, are all going to be paid from sources outside that 13.5, and the entire 13.5 is going to be for the fire victims. Again, we can't promise that, but if you look at how the state of California agreed to take their money, which was solely based on two things. One is stock appreciation, and the other is interest on the money earned. It's very apparent what they think is going to happen with the stock. And then the same thing with the federal government. They agreed not to touch a penny of the 13.5 billion unless all of the fire victims were 100% paid. And they agreed to take their money for the damage to their land. There were BLM and some other lands that were damaged, 117 million worth, solely out of the third-party contractor suits. Now, we've talked about this before. We believe those suits are going to be worth somewhere between 500 million and $1 billion. So we believe that after the trustee pays the attorneys who go get that money and pays the 117 million, there's still going to be hundreds of millions of dollars left for the individuals. And hopefully that will be more than enough to pay all of the administrative cost and still have some left over. So that would be the answer to Mr. Trossel. Again, absolutely everyone has the right to comment. Everyone has the right to say that the deal does not make sense. What I tell people is anytime someone recommends a document or suggests that you look at a document, do it, because when you look at the document, oftentimes it doesn't say exactly what the individual thought it does.
Thank you. We have another comment. It says, will you keep fighting for us to get a better deal due to the stock issue?
Well, the answer to that is that there just is no better deal. There is not a deal. We've signed a deal, and the deal is that we get this amount of stock, and we signed an agreement as to how it was calculated, 14.9 times the earnings, and then we did rework it due to the concern about the dilution from 20.9 to 22.4 or 23.5, somewhere in there. But in terms of redoing the deal, no, we are not going to do that. And the reason for that is this. If we go back on the deal, then PG&E's backstop partners, meaning the individuals who put the money up, and by individuals, the banks, the hedge funds, the banks who are bankrolling the $60 billion, well, actually 59 and change, that's necessary in order to do this, have the right to walk away. And the concern we have is that we do not want to do anything that would remove the victims' rights to say yes or no to the deal. In talking with my clients and talking with other attorneys about what their clients say, the overwhelming majority of people say that while they understand that stock is a risk, they also believe this is the best deal available and they support it. And the concern that I have is if we do something that blows up the deal, then it disappears and the victims no longer have the right to vote on it. So what I would say is this. What people should do is say whether they support the deal or not. If they vote in favor of it, and if more than 2/3 of the individuals do, then it will go forward taking the risks with the stock. And again, there are many reasons to believe that the stock is going to be worth more, but there's a chance it could be worth less. On the other hand, if the victims don't want to take that, then we go back to square one and we try to figure something else out. But in my view, I just don't think it makes sense to take this out of the hands of the victims by doing something that violates the deal.
There's a follow-up here on the chat. It says, if our settlement is paid in stock, what happens if PG&E sells or the stock tanks?
Again, your settlement would not be paid in stock. It will be paid in cash. I assume that question means if the trust is paid in stock. And the question is, what happens if PG&E sells a large amount or the stock tanks? The same rules that govern when the trust can sell its stock and put limits on how much you can sell at any one time will apply not just to the equity holders of PG&E, but to anyone who owns a significant amount. So that I don't think is a concern. It's really not in anybody's interest to tank the stock who owns it. In terms of the next question, what happens if PG&E stock goes down? Obviously, anything is possible. But when you look at PG&E historically, and when you look at the utility industry historically, it's very unlikely. For example, PG&E declared bankruptcy in 2001 and emerged in 2004. After it emerged, its stock went up, and it went up pretty substantially. Here, we're getting the stock at 14.9 times the earnings. The average in the utility industry is 17 1/3, 17.33. So we're getting the stock at roughly a 20% discount. And the reason that we're so excited about that is the reason that PG&E has traditionally been worth less than some of the other utilities is the fire concern. It's obviously huge. But what is new now and what's never existed before is AB 1054. AB 1054 essentially insulates PG&E from fire liability. What it does is create a $21 billion backstop that is guaranteed by the state. And as long as PG&E and the other utilities, Edison and SDG&E, as long as they comply with the plan that they submit to the CPUC in terms of maintenance, inspection, repair, those types of things, then once their insurance is exhausted, they get to access this fund. And this fund was created specifically for this purpose. What had happened is that once the state decided that it did not want to take over PG&E, and as you remember, that was something that Governor Newsom was talking about, the legislature was talking about it, but it simply didn't have the votes, and Governor Newsom decided that that was not something that he wanted to support, which is why he's supporting the current plan. But once it was decided that the state didn't want to take over PG&E, then they said, okay, we've got to shore up their ability to raise money. And the way they did that was by removing the risk of fire. So if there is a major fire event next year, which obviously everyone hopes there won't be, but if there is, and PG&E's equipment started it, then as long as they've complied with this plan, they are able to go to the fund and get everything over their insurance paid for. What that essentially does for the value of the stock is it transforms PG&E from a risky utility into one that is essentially the same as all of the other utilities that trade so much higher. So what most analysts believe is going to happen if PG&E is able to successfully emerge from bankruptcy is that the stock is going to go up significantly. Again, that's what happened in the 2001 bankruptcy, and that is what utilities traditionally trade at. So I certainly can't tell you that there's no risk, but we don't believe the stock is going to go down. To the contrary, we think it's going to go up.
And another question is, how soon will we know when the needed votes have been reached?
We'll know for sure by May 15th. We should know in advance of that. One of the things that we're going to be doing is, now that people have had some time to digest the information, read whatever they'd like to, hear about it from different folks, we're going to be sending out texts and encouraging people to vote. And this is something that a lot of other attorneys are going to do. We'd like to have a sense of where we are by the end of the month. The goal is for us to get as many votes, whether they're pro or con, in by the end of the month, and then we'll all compare notes and we'll have an idea as to whether or not the plan is going to be approved. Again, so far it's been overwhelming. Again, ours is 98%, others are at 95, 97. So we think it's going to be overwhelming in favor of it, and we should have more information in a couple of weeks.
And I have a question from Sydney Howerton.
Mm-hmm.
Actually, it's Michael. Can you hear me?
Yeah, sorry, I
Yes.
just went by the name that's on.
Sorry about that.
Oh, that's all right. First of all, the last town hall meeting I was able to go to, we were talking about the property list not being essential. Now it sounds like it is. Is that true? Second of all, who's going to initiate the contact with us as far as Gus giving you our story about what happened that day? Do we need to set up a meeting with you, or are you going to call and set up a meeting with me? And then the last question I had is, where did we get that 14.9 that we're multiplying the estimated earnings by? Where did the 14.9 number come from?
Okay, all of those are good questions. Let's start with the first one. Personal property lists. It is not required. It absolutely is not. We're working with the claims administrators because some people simply aren't able to fill one out, so that they will be able to come up with an estimate. That said, I strongly encourage you to do one, simply because the only way that we can make sure that we get you compensated for everything is if we know what you have. So again, totally your decision. You don't have to. You will be able to obtain some compensation. But again, I can't tell you with any certainty that I am going to get you 100 cents for everything that you lost if I don't know what you lost. So that's number one. Number two, in terms of contact, generally what we do is we reach out for your narrative once we have the other information that we need. Now, that said, if you want to do your narrative now, no problem. Either call, email, text us, and we'll go ahead and have somebody set it up with you. Due to social distancing, it's not going to be able to be in person. It'll have to be Zoom or telephonic, but if you want to do it right away, no problem at all, we can do it. Lastly, regarding the 14.9, that was the result of negotiations back and forth. Obviously, they wanted to do it at the 17.33 because that would have meant that there was less of a discount that we were receiving. Our argument was, we understand all the arguments as to why PG&E is going, the stock is going to rise. And again, we certainly believe that it will, but we want to hedge our bets. So we want a discount on that stock. And that's where we came up with the 14.9. Because again, what we believe is going to happen is that as PG&E gets out of bankruptcy and moves forward, and Wall Street and other investors see that AB 1054 is a safety net, they're going to start treating PG&E the same way they treat other utilities. It's going to start trading closer to 17.33, and the value of the stock is going to go up dramatically.
Can you elaborate on, it says here, you mentioned that PG&E would end up paying the attorney fees and costs. Can you elaborate how that would work in a settlement?
Sure. The way that we do it is this. We come up with what your economic losses are. And then, and let's just use the example before. Let's say they were 100,000. And so you take 100,000 and then you figure out what you would have to pay for attorney fees. You put that on top of it. On top of that, you put any fees and costs. And these would be, let's say that you lost a structure, and so you needed to have a contractor come out and do a report. You put that on top as well. Whatever the costs are, we put those on top. And that way we make sure that the total amount you receive includes the fees that PG&E has to pay for. It's a little bit different than if you have a jury verdict. If you have a jury verdict, then at the end you make a motion and the judge says, I'm awarding X amount of fees. Here you can't do that because there isn't a judge. So the way that you do it, and this is the way we've done all prior settlements going back to San Diego, which started 11 years ago, you do that method and it results in the individual receiving 100 cents on the dollar for their economic damages and still receiving something for their non-economic damages. We call that offhand the Trotter formula, and it was named after Justice John Trotter, who is the trustee here. So that's why we're very confident that he is going to use the formula that he created and that we used in San Diego and Butte and all of these other fires that we've handled to resolve these cases.
Okay. We have a few participants on the phone, and I'm unable to see if they have questions or not. I'm going to go down the line and then mute them, see if they want to.
Okay, sounds good.
All right. Number ending in 7554. Hi, how are you? Do you have any questions?
And again, does anyone have any questions on the phone? Anything that's come up that you've heard about in the media, social media? We really want to make sure we answer everything. Yes, sir. Sure, you see that?
One sec.
Yeah.
Who is it? Mr. Yeah. Go ahead.
Yes, I do have a question. I own a small business, man. I'm a landscaping called Sandy Spring Landscaping, and I lost a lot of all my equipment, the trailer load and all the equipment up there because yeah. Also, my friend, he died. You know, the guy who is my helper. You know, I never got him, and after that, I never ever to come back to my property for months. You know, I got ransacked and all of my diesel, the power generator, all of them being stolen. And yeah, and I was in a very deep depression. Eventually, I went to medical treatment for mental depression, and I was ever to go back to work because I do not have all my equipment to go out and cut the grass. So, this has been going on. So now here in 2020, although I lost in 2019, which is,
Okay. So you were cutting in and out
how
a little
possibly
bit?
I can.
Go ahead.
Okay, I own Sandy Spring Landscaping. Okay, so I lost all of my landscaping equipment in the fire up in there. We barely run out because everybody had to leave. So same time, I can't come up to my place because our car doesn't make me to go up to the mountain. I live in 2,500 feet sea level, up in the Ball Rock, which is above the Orville Dam. I live there. But I go to walk in paradise for landscaping. So that's why I lost all my equipment, everything. I had to barely run up and jump in the sun. That's how bad situation was. And I never found my friend. He's gone. So I went to depression for a long time. And those medications made me crazy, so I had to quit it. So I lost all of my memory and stuff like that. So I'm still fighting for it. I still try to normal, try to try to function myself from mental, and physical, of course, trying to do it. So sometimes I forgot things, so I write it down question. So that's my question. So do I have to make all the list what I lost, or do?
Well, first of all, I just want to say how sorry I am and how just phenomenally gut-wrenching that must be. I'm so sorry that you lost your friend. In terms of the business, of course, you can recover not just for the items that you lost, but also for the lost income when you weren't able to work because of the lost equipment, and also because sounds like you had severe PTSD, and you can recover for that as well. In terms of, and I think your question precisely was about making a list. Obviously, the more information we have, the more we're able to recover. But I think the best thing to do would be to have you sit down with one of our people, and we'll have to do it remotely given social distancing. But we can talk and we can go through what the list is, and then we can work on it from there. But the damages are so significant there that I think it makes sense to have a more in-depth call either tomorrow, or if that's not convenient, then early next week.
I have a question from Ms. Susan Thomas.
Sure, go ahead.
Hi, actually, Mark and Susan. Hi.
Okay.
Hi, Jerry.
Hi, Mark.
These last two sessions, we're impressed by your ability to hold the content without something in front of you reading.
Yeah.
Pretty darn cool. Anyways, PG&E has, severely negative earnings, right? They're like minus $15. How does that affect the payout? The second question. Well, let's just go with that question.
Sure. Yeah. Right now, and the reason that we're not using last year's earnings or this year's earnings is because of all of the money that they are taking as losses. So you're right. I mean, it's just completely devastated it. And it's based upon 2021. And the reason that we have a pretty good idea of what they're going to earn is that we know with a great deal of certainty what they can charge because they're a regulated utility. So the way that they do it is the accountants do a projection based upon prior usage and what the rates that have been approved by the CPUC are. So while those rates or while those earnings aren't precise, they're pretty close and they're not going to be adjusted much. And all we do is we take those projected earnings and we multiply them by the 14.9, and that's where we get the overall market cap. And then the trust gets, again, a minimum now of 22.4%, which could go up. So that's how that's done.
Okay, great. Thanks.
Sure.
I have Earl Persons.
Okay.
Yeah. Excuse me. Can you hear me?
We can. I'm glad you got the ear. I saw you doing that earlier.
Yeah. Well, I had a little trouble hearing your audio, but I got it figured out, so I got that straightened out. My question is, when it comes to the value of the property that I lost everything, house, everything. What kind of documents do I need to claim the value of the property?
Well, it really depends. It's kind of a case-by-case basis. When you are in a situation as you are, where everything's been destroyed, then obviously your ability to provide most information, receipts, photographs, things like that is very limited. And
I've already submitted a list of personal property loss. What I'm getting at is the value of the house and and the land on it, because we're still having to pay property taxes on the land even though I don't have a house on it.
Understood. And two things there. Number one, they should have reduced your property tax based upon the fact that the structure was destroyed. If that didn't happen, please let me know and we can help you with that. Number two, the way that we calculate it is a little bit different. You can, if you, for example, have sold the property, which you haven't, but if you had, then it would be diminution in fair market value. So we would have an appraiser come in and say, prior to the fire, this property was worth $750,000. Now it's worth $100,000, and so the damage is $650,000. The way we do it is different, and what we'll do, we'll get an expert to give us the cost to rebuild your home, and also get experts to talk about all the damage to the land itself. And typically, that is erosion is number one, but the most common are trees, landscaping, things like that.
Yeah, I lost a lot of trees.
Exactly. And usually those components together will come out to be a little bit more than what the pre-fire value of the property is. And that's fine. The case law is very clear. You're entitled to recover more than the property value for all the components, as long as it's reasonable, meaning it can't be 10 times, and as long as you have a personal reason for doing so. And that reason can simply be that you'd like to have your house back. The law has really evolved a lot on this in the last couple of decades, and it's recognized that property is not fungible. People love their homes, they've lived there for a long time, or it could be you just bought your dream home, whatever it is, land is not fungible, and so people are entitled to be compensated fully in order to put them back where they were before. So that's what we'll do. We'll get the experts out there, and that should be all you need. Going back to the other, if you have pictures of big ticket items, those are always good. But if you don't, then that's fine. And for pictures, obviously anything you had that was a physical picture was probably destroyed. But one thing that we really encourage people to do is talk with friends, because most of us store our pictures on our phones, or a lot of people have Facebook, younger people have Instagram, those kind of things. And you'd be amazed at what you can find if you ask friends, relatives, particularly younger people, to look on them. They will oftentimes have a lot of pictures of the inside of your home. They could have been taking pictures of something else. You know, for example, your grandchild could be taking a picture of you, and then in the background, you'll see all this, and it can be very helpful in terms of proving what you had.
Well, thank you. One more, in response to one of your answers, does it matter if we plan to rebuild or not rebuild?
The answer to that is it does, in terms of whether or not you can recover the full value. So what I always say to people is this: if you have decided that you are not going to rebuild, and you've either sold your house or you've said, look, you know, for me, no matter how much money I get, I'm not going to rebuild, then obviously, you know, that's your decision. You have every right. But you are limited to diminution in fair market value, which is going to be less. On the other hand, if you're not sure, if you haven't made up a decision, haven't made up your mind yet, and you want to see how much money you get from this and then determine what makes sense for you economically, then you're entitled to recover the full amount. So
I see.
Yeah.
Yeah.
Again,
Okay.
this applies to everyone. At some point, you will have to make a statement as to how you want to proceed. And I can't tell you how to do that. That's up to you. Obviously, you need to tell the truth, and I know everyone will. My job is just to tell you what the consequences of the decisions are.
Okay, thank you very much.
Certainly.
I have a question submitted via chat.
Mm-hmm.
How does a renter versus owner loss work as far as being compensated?
The difference between a renter and an owner is simply that renters are entitled to recover what they lost, which is usually everything but real property. If you were a renter, you rented your home, but typically you owned everything that was inside it. There are very few cases where someone had a fully furnished rental, in which case they wouldn't be able to recover most of the furniture. But for most renters, they rented the structure, but they owned everything inside it. So if you're a renter, you can recover all of your personal property that was lost. And typically, they also have emotional distress, and in very rare circumstances they may not, but generally, you know, they fled from the fire, they suffered the loss of all their worldly possessions, and so they're entitled to be compensated in the same manner as an owner. The difference, the main difference between the owner and the renter, is the owner is going to be able to recover for the real property damages, obviously minus what they got for insurance.
And I have a question from Joe Innocenti.
Yes. My question is, I'm curious of why there is no campfire survivors representing on the TCC.
Okay, I believe there actually are still two, if I'm not mistaken. I know that two resigned, but I am almost positive that there are two that are still on there. There is a woman who I believe lost her father, if I'm not mistaken. And then there's another gentleman, and off the top of my head, I don't know what his specific losses are, but I know the attorneys who represent them. My understanding is right now there are only 8 individuals. There are 2 from camp, 2 from Ghost Ship, 3 from Tubbs, and I believe 1 from Atlas.
Okay. Yeah, I appreciate that clarification, because what I pulled up online, I was only showing 5 plus the 2 that resigned. So now if you're saying there's 8, that would make sense of the other 2. Okay.
Right, yeah.
Great.
And if you need the names for any reason, please just send me an email and I can look.
No, there's no reason for the names. I just want to make sure that the campfire survivors, that we are being represented on the TCC.
Yes, sir. Yeah.
I appreciate it. Thank you.
Sure.
Let's see. Have anybody else? Any other questions? If you're able to hit that raise your hand option, you can physically just wave and I'll unmute you.
Yeah. The other thing I really want to stress is if anybody is interested in hearing, not just from me, but from other attorneys as well, there is going to be this roundtable on Saturday at 12, and we'll give you a call beforehand. So if you're interested, just stay on the phone, or you can stream it. And then we'll do another one of these on next Thursday to answer any questions that come up. Also, there's no need to wait. If you have questions as you go along, if you see something on social media and say, you know, I'm curious about that, please email us. One thing we want to make sure is that you have all possible information. And again, if we don't know the answer for some reason, we'll find out and we'll get it to you. Do we have any other?
Yes.
Okay, go ahead.
1 second. Oh, looks like she doesn't have any audio.
Oh, okay.
Hello, Jerry.
Yes.
Hi, it's Erica.
Hi, Erica. How are you?
Hey, how's it going? Can you go over with everybody how they vote one more time?
Sure. So there are two main ways to vote, online or by mail. Obviously, if you want to go by mail, you just fill it out, you mail it in. Again, it must be received at Prime Clerk's office in New York by May 15th. So given particularly the problems with the post office right now due to the COVID pandemic, I strongly encourage people to get that postmarked at least 2 weeks before to make sure your vote counts. The way that they've asked you to vote is online. And again, the problem is, and this is 100% their fault, it's not anyone's fault, no one did anything wrong, but for whatever reason, their system does not react well with smartphones. So most people are having trouble with their smartphones. So what we're going to do is send you a text, and we're going to give you a survey. You fill that out, you give all the information, you instruct us to vote for you, then we will go online, vote for you, and confirm that that was done so that your vote counts. If you have access to a computer and you want to vote for on your own, then all you do is you click the link that we sent you along with your e-ballot number, and it's the one that says restructuring, Prime Clerk, PG&E, e-ballot home. You put in your e-ballot number along with your name and your email address, and then the website will take you to an online document that is the ballot. You go to page 7, and obviously you're welcome to read the whole thing, but if you just want to vote, then you go to page 7 and you choose accept if you want to accept the plan, reject if you do not. You then go to page 8 and it asks for your personal information. You don't need to fill this in, but you can. Again, if you do, we strongly encourage you to only use the last 4 digits of your Social Security. Then you click electronically sign, which is right there, and you type in your name, and then you submit. Again, if you have any questions at all, please let us know. And just to reiterate, every person in your household, adult, child, business, trust, or estate, everyone has their own vote. If you're an adult and you have a minor child, then you put in the child's Social Security number. Again, people may, the last 4 digits. This has been more complicated than it should have been. So if you have any trouble, please call us and we'll help take you through it.
And how will they know that their vote went through?
If you vote electronically, then you will receive a confirmation email from Prime Clerk. Obviously, if you vote via mail, then that will not happen.
Okay, thank you.
All right. Okay, does anyone else have questions?
Person.
Okay.
Yeah, can you hear me still?
Yes, sir.
Can you see me?
I can.
Okay, I am not Earl. I want to apologize for misrepresenting my brother.
Oh, not at all. No.
My name is Bruce. Okay, so, okay, I'm helping him with this problem because he's, how do you say it? He's not really computer, computer literate. So I'm helping with him with this problem. But I
Right.
do have a question. You said that every member in the household can vote.
Right.
So to identify each member in the household, they have to go to the next page and fill out their identity with the last 4 digits of their social security. Is that what I'm hearing?
No, not quite. The way that it works is every individual who has the right to vote will get their own e-ballot number.
Oh, okay.
Yeah, so if you're a family of 4, for example, a husband, wife, and 2 kids, we would send you 4 e-ballot numbers, 1 for each one of you. Then you go in, if you're going to vote for your children, for example, and I would put my name in, my e-ballot number, vote yes or no. Then I would do the same thing for my children. I would put their name in, their e-ballot number, and then for the social, I would list the last 4 of theirs, vote for them, and then go on.
Okay, so in order to get an e-ballot number for everyone in Earl's household, he needs to ask for those three separate ballots. Is that correct?
Yeah, all he has to do is just email us, and he can email me, he can email Erica, Chewy, any of the people in our office, and just
Okay.
say, I would like my e-ballot number, and say, I would like it for these people. Give us the name.
Okay.
We'll give you the e-ballot numbers, and they're good to go.
Oh, I see. Okay.
Or you can do it if, let me just say, if it's an issue of he has issues with computers,
Yeah.
you'll do it. You can call us, and we can do it that way. Whatever the easiest way to do it is.
Okay, but each member of the household has to have a separate e-ballot number. Is that correct?
Right, and Prime Clerk issues it based upon a proof of claim. So what usually happens is we file a proof of claim for each person in the household, and then Prime Clerk issues that e-ballot number for each individual.
Oh, okay. So will those all be on the same mailed ballot that he was supposed to receive?
No, each person will receive a separate e-ballot number. So if they ask for it to be mailed to them, then they will each receive one. However, we can get them for you. So if for some reason he doesn't have it, or anybody on the call, if you don't have it, let us know. We can get it from Prime Clerk and give it to you so you can do it.
Yeah, the problem he's having is that he moved since from one location to another location, and apparently they mailed it to his old location, and he's trying to get that straightened out right now. So I'm not sure he understands that he has to have three separate ballots.
Understood. Why don't we do this? If you just want to call the office tomorrow,
I'll
we
have
can
him do
walk
that.
you through it, and
Yeah.
or him through it, whatever's easier, and we can arrange to get this done however it works for him. If he
Okay.
wants to do it for him, if he wants us to mail it to him, we'll get it done.
Well, I'm going to talk him into letting me help him do the e-ballot, because that'll be a lot quicker.
Perfect.
Plus, he'll get an email clarification,
Right.
because we have, well, because of the mailings, the USPS
Sure.
is a little
Understood.
slow.
Yeah,
So,
makes sense. Yeah.
okay, all right.
All right, no problem.
We got Eric. Erica, go ahead.
Hi, can you hear me?
Yes.
I would encourage everyone to look in their email to see if they received something from info@slffirm.com. We have now sent out all the e-ballot numbers to every household.
But again, if you didn't get them, no problem. We'll resend them. We can, do whatever you want. We want to make sure everybody has access and can vote. Chewy, do we have any other questions?
Yes, there's just, in the beginning, you mentioned the town hall on Saturday.
Yes.
They want to know, can you mention what that is and how to join it on Saturday?
Yeah, absolutely. There are 2 ways to join the town hall on Saturday. One is you will receive a call from us, and it will say, it'll have my voice that's recorded, and it'll say, if you want to join this, then just stay on the line, because it's a telephonic town hall. The other choice is you can go to firesettlementfacts.com and stream it that way. I think it'll probably be easier to do the telephone because the streaming is a little hit or miss sometimes, but those are the options. In terms of what it's designed to do, there are several other attorneys that I've worked closely with during this case. We're not, we don't have the same clients, but we all work together to get this deal. And together we represent about 30,000 individuals. So the idea is that some of our clients may have questions that are going to benefit somebody else's clients. And so we're going to call as many people as we can. We expect to have several thousand people on the phone. We're each going to say a little bit about what's happening now, go over the voting, provide general information, and then we're going to open it up for an hour and a half or so for people to ask questions. And the goal is to get as much information out and have as many questions as possible answered.
Okay. I don't see any more questions. Anybody raising their hand? We will be recording, and I mean, this is being recorded and it will be posted on our website.
Right. And again, I just want to thank everyone. We are going to be reaching out a lot in the next couple of weeks just to make sure, because of these issues with Prime Clerk, to make sure everybody has the opportunity to vote. Please don't feel pressured. If you want to wait to vote, that's fine. If you want to vote no, that's fine. It is completely your decision. We recommend yes because we think this is the best possible result, but it's 100% your decision. And again, if you have any questions, please call or email me, and I will get you whatever information you need. Thank you very much, and take care, everybody.
Thank you.